Hi, Bill Henshaw here for the Constitutional Crisis channel again. This will be one of our longer, more detailed videos, but not strewn with a lot of legalities there, so don't be concerned about that. But I'm going to read an excerpt from one of the most important cases I think ever decided, and you've never heard of it. I didn't either until I came to California and started to study common law. Case is State versus Hopkins, 213 Oregon Reporter 669, decided in 1950. And this involves, and you're going to see exactly the application, it involves a case where the Oregon legislature changed the laws and took away the judicial court that this judge was sitting in who brought this lawsuit, and he lost him his job, and naturally he wasn't too happy about that. So he gets to the Oregon Supreme Court, and the first excerpt I'm going to make a departure because I thought I would just read this straight through, but it's so important. You're going to see what's happening here. It starts out, the defendant has filed a petition for a rehearing which does not challenge our holding that since the enactment of the Oregon laws in 1951, the county judge of Jackson County no longer possesses any judicial power, and the county court over which he presides no longer performs any judicial function. What has happened here is the stupid judge should have challenged it. He should have known better and said, wait a minute, because the changes in the Oregon laws in 1951 are based on, guess what? The 14th War Amendment. That's the only way they could possibly do this. If he had challenged the constitutionality of that amendment, which is exactly what I'm doing today, 65 years later, this case comes out differently. And this, by the way, and we'll go into Ashwander in a separate video later, but this is Ashwander. I've been talking about this in other videos. The court will not anticipate a question of constitutional law and the advance of the necessity of deciding it. He didn't ask, they ducked and dodged. That's exactly what went on here. Case goes on. It will be noticed that the change in the county court wrought by the legislator was fundamental. After the adoption of the 1951 Act, the county judge no longer had a 6-year term of office. His salary was no longer immune from reduction in amount. He no longer performed any judicial work, and he no longer possessed any of the powers of a judicial officer. Now, a little aside here, I note that the Constitution itself didn't reflect any of these changes. They didn't bother to tell you what the hell it was they did. It looked for all the world like he's a judicial officer, but he isn't. This would be separation of powers if we were in a state court at the time. We're not. This just makes my case state versus territory. If they're territorial legislative tribunals, there's no problem with that. There's no judicial courts in a territory. It's a killer. Okay, it goes on. The Act enacted pursuant to the Constitution of Oregon, Article 7 amended. That's the one that they did pursuant to the 14th War Amendment. Likewise, the petition for a rehearing says nothing adverse to our conclusion that since 1951, the county judge of Jackson County has possessed no powers except those which are purely administrative. This is exactly like a tax court, people, Article 1. I mean, you get into the IRS and the tax boards, they're not in a judicial court, administrative tribunal, which they never tell you that. Okay, it goes on, purely administrative, and which are employed in the transaction of county business. In determining whether or not the office of county judge of Jackson County was quote-unquote created by the legislative assembly, as that word is employed in Article 15, Section 2, account must be taken of the purpose of 15.2 in prohibiting the legislature from interfering with the term of office designated in the Constitution. Since the amended Article 7 authorized the legislature to abolish or remake the county court. Accordingly, since when the legislature picked up the gauntlet and enacted the 1951 legislation which deprived the county court of Jackson County of all of the judicial powers which originally Article 7 had conferred upon it and left it with nothing but administrative functions, it cannot be said that the legislature invaded in an unauthorized manner a provision of the Constitution. The reason it can't, just another aside here, is that since The state constitution at that time, and really much before, no longer recognized lawful de jure free white state citizens who had creator-endowed inalienable rights and the right to judicial process in the first instance, that they were fully within the scope of their perceived authority to do what they did. In doing so, however, they assumed facts not in evidence, like, for example, the 14th War Amendment was lawfully ratified and it wasn't, and that every litigant that came before this court, now known as an administrative tribunal, owed his citizenship to Section 1 of the 14th War Amendment. They can't do it. There's no factual foundation and legal basis, and that's what it is we have to challenge. This goes hand in glove with my video on subpoenas, as we discussed earlier. Case goes on, and it said that not only this, but the Legislative Assembly, in embracing that power to change the courts, retained only the name of the body, but changed it from a court to an administrative unit. And we believe that the conclusion is warranted so far as Article 15.2 is concerned, that the legislature created the County Court of Jackson County. So they changed the name, changed the powers, and didn't tell you a damn thing about it. That's a hell of a fine way to run a Republican form of government, don't you think? Not only that, this case happens to be in Oregon, but the good news here, especially for those of us in California, but I believe in all the territories, is this decision operates by operation of law that applies in any state that's been relegated to a territory, and they all have been. So that's good news, and here again the Northwest Ordinance comes into play. Congress specifically included that when they created the Oregon Territory in 1848. And I think since Congress has somehow relegated states to territories, we're back in business again, and the Northwest Ordinance says the inhabitants of the territories have the right to trial by jury, the writ of habeas corpus, and proceedings according to the course of the common law. This case can't make it any clearer than that. And if you want a copy, please check in with me at my website here, ckaspari@live.com. And I invite you to watch some of my other videos at Bill Henshaw Constitutional Crisis Channel. Thank you.